pleasure to welcome to the Oxford Jurisprudence Discussion Group Professor Ralf Poscher. Professor Poscher is director of the Max Planck Institute at Freiburg and professor of law at the University of Freiburg. Thank you very much again, Ralf, for joining us today. And today we will be discussing his paper, Discretion and the Descriptive Inexhaustibility of the World.
Yes, thank you very much. Thank you very much for having me. It's a great pleasure to come here. And maybe to start off, to give kind of a framing where this paper belongs. So I have a larger project which I would call the analytical reconstruction of legal hermeneutics. And the basic idea is that especially adjudication, the application of the law, involves a whole series of activities, and not only interpretation proper, but also something like rule following, something like legal construction. It involves the construction of legislative intent and also discretion. And so the idea is to build this analytical account in kind of building blocks of these different activities. And as you can easily, already by naming the topics, how we can easily see that behind many of those topics there are some discussions in analytical philosophy that might help us to understand what we actually do when we apply the law. So very obvious with the question of rule following, the rule following discussion, question of interpretation, the question of how do you construct, and I would follow a model that's rather on an intentionalist basing, and so on. With discretion, the philosophical problem behind it, or problem or phenomenon that one could elucidate, is not as well discussed as some of the other topics. But a friend of mine, with whom I worked for quite a while on two larger projects, Gerd Keil, he had this wonderful paper on the descriptive inexhaustibility of the world. And I think it links nicely. It is the theoretical problem in the background of discretion, I think. So I would also, for the sake of time, skip kind of the history of the discussion, because in a way one could say the discretion discussion, if you compare it, for example, with interpretation, is a little bit the kind of neglected child of the legal theory topics with respect to legal hermeneutics. So there's not much ink spilled on it, but as you can see in the paper, all the big names, Kelsen, Hart, Dworkin, they all said something on discretion. And also, I think, in a way, they also shared a sensitivity for the distinction that I'm after, namely the distinction between legal hermeneutics on the one hand and the exercise of discretion on the other side. And maybe less, the least with Hans Kelsen, but even with Hart, you can see that he also makes differentiation in this paper, and Dworkin is pretty close to what I think is a constructive reconstruction of what goes on when we exercise discretion compared to interpretation, for example. So when we start from the very basic notion that the law has to describe reality to regulate it, it has to give, in the broadest sense, in linguistic accounts of the events it wants to regulate, and it also has to describe the events that ought to take place via language. It has to describe the events that constitute a contract, and it has to describe the actions it wants to take place once the contract has been formed, like the obligation to pay a price. Thus, the law always relies on the relation between events in the world and the description of these events in the law. And the thesis is that discretion is the result of a specific underdeterminacy in the relation between the events in the world and their description. And this underdeterminacy is not due to the indeterminacies of linguistic expressions, but due to a structural feature of events and their descriptions, namely that the description can never exhaust the real-world events they describe, and thus have to leave an infinite number of properties undescribed. And this leads to an incompleteness of the description concerning the aspects the law does not address. And in linguistic terms, it leads to the generality of legal descriptions of the world. I employ the term underdeterminacy here as a generic term of art that is supposed to build the genus proximum for the descriptive incompleteness leading to generality of legal descriptions on the one hand, and the linguistic indeterminacy on the other, caused by vagueness, ambiguity, multidimensionality, context sensitivity, and related linguistic phenomena. So this whole idea of the descriptive inexhaustibility of the world, it can be traced back. My colleague thinks there are even traces in antique discussions, but it really shines up in German Romanticism, at least, where there was this idea that the individual is so special and cannot be described in his full identity by abstract concepts and what have you. So there was a saying of the individuum as ineffabile. And this is a term that Goethe and other literary persons of literary standing used quite frequently in German Romanticism. And then this idea is also, I think you can see the next more theoretical uptake of this idea also in literary theory, where especially Ingarden talked about the necessity of blanks and gaps, or as he calls it, places of indeterminacy in fictional texts. And many of you probably know the philosophical essay from David Lewis on truth and fiction, and there again it's the same idea that fiction and has necessary gaps. And Lewis has this example of the blood type of Inspector Lestrade in the Sherlock Holmes novels. So there's just nothing in there, so there can't be any truth about this point. But underlying is this idea that the description, the fictional description, have to have these blanks. And I think a more recent example where this idea lingers in the background is Ruth Millikan's book, Beyond Concepts, which develops the referential semantics, is very skeptical about concepts as such, at least understood as concepts that have necessary and sufficient conditions. And her point to make this vivid is Helen Keller. I don't know if you know Helen Keller. Helen Keller is an American disability rights activist, but also very proliferate author. And she got sick at the age of 2 and fell blind and deaf. But nevertheless, she had a career as a writer. And Millikan's point is how Helen Keller would describe certain objects in the world must be radically different from how we do it, since she's deprived of some of our main senses, and how she keeps track of objects in the world. So her idea is, it just goes to show that it doesn't make much sense to talk about concepts, because the concepts that are in the end are very idiosyncratic if we go into details how each of us tracks certain objects in reality. And I think it's the same idea in the background, because the mechanism why this is so, because reality has this inexhaustible reservoir of qualities that we can use to keep track of things. So these are some of the philosophical background noises that you can find where this idea plays a certain role. And then my colleague picked this up and coined this term of the inexhaustibility of the world, the descriptive inexhaustibility of the world. So the world is ontologically dense in the sense that each object and each event has an infinite number of properties. And that is probably easiest to grasp if you think about relational properties. Like this microphone has a certain spatial relation to this bottle, it has a certain relation to this room, to the city, to the planet, to every object in the universe. And since there's an infinite number of objects in the universe, already the spatial relations of this object are infinite. So, but it holds for many other properties too. And we can never exhaust the number of properties objects have. So this is the basic idea. And this incompleteness of our descriptions then can translate into the generality of descriptions due to the aspects of an event or object the descriptions do not address. With respect to past and current events, incomplete descriptions are able to refer to a specific object or event. And this referential quality of descriptions is often stressed in referential semantics. In a room with a couple of different colored chairs, the description, the red chair, is sufficient to refer to a single red chair in the room, even though the description is quite basic and leaves out an infinite number of properties of the chair. But with respect to future events, our necessarily incomplete descriptions are only capable of determining a set of possible events. We might be able to predict that there will be a thunderstorm on the weekend, but the description will fit a whole set of thunderstorms with different numbers and sizes of lightning and thunder, from which only one will materialize. And the same holds for descriptions of future actions, as they are used in normative contexts. If an employee is asked to pick one of the red company cars parked in front of the office for an errand, the description relates to a set of cars and leaves undetermined which car she picks. And this kind of underdeterminacy, stemming from the necessary incompleteness of our descriptions of future actions and the generality of the description it ensues, is distinct from the linguistic indeterminacy that can stem, in the example, from the vagueness of the predicate red. If there is a reddish-orange company car parked at the curb, it might be indeterminate whether the speaker would consider the orange car already as red, and thus whether she could have meant the orange car too when she was referring to the red cars outside. The two kinds of underdeterminacy correspond to distinct linguistic phenomena that are sometimes confused and wrongly associated: generality and indeterminacy. Roy Sorensen made quite a point out. You definitely know his essay on vagueness has no function in law, where he stresses the point that some of the features that H.L.A. Hart, for example, ascribes to vagueness of legal terms do neither enable the law to rule on a great number of cases, nor is vagueness the necessary price law has to pay for this feature. The advantages that Hart associated with vagueness are due to its generality, and vagueness and generality do not necessarily associate. Jeremy Waldron provides the example of two concepts, living being and bush. Living being is far more general than bush, but it's also less vague. And here's where I stumbled upon your administrative law book, because you had this nice example. Let me find it, where you say, suppose I ask somebody to come to my party, and you ask, you should turn up, and I say, oh, please come early. It may not be clear how early is early, and then my request is vague, because there is no sharp boundary to the actions that count as complying. I have not simply asked you to come whenever you please. I'm giving you a standard for your behavior, and if you don't come early, you won't have done what I asked. But the vagueness in my request, that is the imprecision as to when early starts and stops, gives you some degree of choice. And then you associate this degree of choice with discretion. And I think there are two things going on in the early example. There is that early might be vague, but early also is general in the sense that it doesn't cover a specific point in time, but a specific period. And what I would say with an example like this is that you have discretion as far as you stay within the period of time devised by the term early, and that there are vagueness issues that come with the borders of the term early, and that will probably usually not be what you're fighting or what you're thinking about when you're thinking about having a choice, that you get into a disagreement with the guy who invited you early of what actually counts as early, but you will probably think it will be something like 15 to half an hour before the party starts, and then you come 20 minutes early. But I think in this example, you could also take apart the aspect of the generality of the term early, that it covers a whole period and that it covers a whole set of time slots, and that it has vagueness at the fringes. So both types of underdeterminacy and both associated features of linguistic expressions, generality and indeterminacy, come into play when we solicit someone to act upon a description. Norms concern not actual but possible events, usually in the form of actions they endorse. And the law consists of norms, usually hypothetical norms. It usually connects the descriptions of an antecedent with a description of a legal consequence. Since antecedents and consequence each consist of descriptions, both kinds of underdeterminacy can occur in either element of a typical norm. If the law provides that the formation of a contract requires consideration, it might be linguistically indeterminate at the margins what constitutes consideration, as it will also be descriptively incomplete and insofar general concerning, for example, the location of the consideration, in an office, at home, in a restaurant, etc. And there are only some contracts in German law, for example, are contracts relating to real estate that have to be actually in the office of a notary. If the law punishes using a firearm in a drug trafficking crime with a prison sentence 5 to 10 years, it might be linguistically indeterminate whether having a firearm in the trunk of a car during a drug sale constitutes use. If it does, the law is descriptively incomplete and thus general concerning the amount of the sentence, namely 5 to 10 years, and any increment in between. The law treats both kinds of indeterminacy usually very differently. Linguistic indeterminacy is subject to hermeneutical determination. It is either resolved through legal interpretation or legal construction. What use requires is either established by reverting to the intentions of the legislator, or, especially if that cannot be established, by doctrinally developing the law with regard to the case through legal construction. And the same for the question of what consideration in the context of a contract formation actually requires. Questions of linguistic indeterminacy are settled by legal doctrines that are developed with hermeneutical methods. Courts and legal scholars have the task of providing a legal doctrine of contract law that settles the question of consideration for fringe and borderline cases. Descriptive incompleteness, however, is not addressed hermeneutically. Where the parties form a contract is left to the parties' discretion. It is left to their will or to their discretion. And there are good reasons why the law treats linguistic indeterminacy and descriptive incompleteness differently. As for the aspects addressed, it seems reasonable that the law regards the aspects of the event that it takes up in the description as legally important. The linguistic indeterminacies that concern the aspects that the law addresses are treated with specifically legal methods that provide for an incremental amendment of the law that respects its coherence, its generality, its pragmatic usability, and its aspiration to justice. As for the aspects that the law does not address, it is already impossible to subject them to a doctrinal development because of their infinite number. Further, the fact that the law does not address them indicates that the law does not regard them as aspects that should be doctrinally developed. In law, there are thus not only two different types of underdeterminacy, linguistic and descriptive. Rather, the two types of underdeterminacy also correspond to two very different ways of resolution, hermeneutic methods of legal interpretation and construction on the one hand, and the exercise of pragmatic discretion on the other. Underdeterminacy in law does not only associate discretion in a wholesale fashion. Even though legal hermeneutics do not always deliver determinate results and thus sometimes allow for choice between equally arguably legal interpretations and constructions, the choice involved is of a different kind. Where choice is involved in the exercise of discretion, it is of a pragmatic specifying type. The choice between different legal interpretations or constructions, on the other hand, is of a doctrinal type that concerns the effects on the inferential network that constitutes the law as a doctrinal system. Whether the underdeterminacy of the law provides pragmatic discretion or merely room for doctrinal development of the law depends on the kind of underdeterminacy, whether it pertains to the linguistic indeterminacy of the expressions used or its descriptive incompleteness. Both types of underdeterminacy and both types of resolving them occur with every legal norm. In principle, every legal norm can confront us with linguistic indeterminacy for borderline cases. And since every application of the norm is an event in the world, it also is the case that every application of a norm is necessarily underdetermined by the aspects of the event that the legal norm describes. Kelsen showed an acute awareness of this latter kind of underdetermination. A quote, "Even the most detailed command must leave to the individual executing the command some discretion. If the organ A orders organ B to arrest subject C, the organ B must, according to his own discretion, decide when and where and how to carry out the order of arrest." End of quote. So I think that is what Kelsen saw quite clearly, that when you have to apply the law, you will always have discretion in the minutiae of the details and how you do it at least. So as hypothetical norms, some legal norms carry the underdeterminacy even one step further in that they provide discretion with respect not only to some aspects of the application of the norm, but concerning the application as such. If the above penal rule determined that the range of the penalty would be from 0 to 5 years, it would leave it to the discretion of the court to even administer a punishment at all. And it is this type of discretion, and you must know this from the German discourse, that is often only associated with discretion, namely discretion if a norm gives the authority who has to apply it the discretion of whether to take the legal consequence at all. And I think that this is much too narrow, that on the contrary, that every norm gives discretion in the application of the norm, and what these discretionary norms, as they are called, for example, in German administrative law, which give the authorities the discretion to issue the consequence of the norm at all, what they only do is that they add one other element to the set of legal consequences that the norm can only describe. So if you think about it in set theoretical terms, it just adds one more element. So that also means that discretion is, as Kelsen pointed out, pervasive in the law. Discretion comes with every legal norm and pertains to the descriptive, underdetermined aspects of its application. What then comes up is when you have this discretion, also in the historical discussion about discretion, was the idea that discretion has to be somehow checked. So what many legal systems did, and at least the German and I think also the European law did it, they developed certain doctrinal elements that try to limit the exercise of discretion. So whether the police officer keeps her nightstick in the left or right side of her belt is entirely up to her. However, if legally protected interests are involved, then some legal systems might place limits on the exercise of discretion. And it is in principle up to the discretion of a police officer to decide if she will wear gloves during a body search, and if so, what kind. But if she knows, however, that the suspect or prisoner is highly allergic to latex, his rights to physical integrity might prohibit her the use of latex gloves. Or another example would be there is no rule, at least in German administrative law, how to print an administrative act, which font size. But if you know that somebody has a visual disability, it would be discriminatory if you choose a very small print size, and it would limit your discretion with respect to the print size. Thus, even though the legal rule on bodily searches in the case of the latex gloves does not say anything about whether what kind of gloves should be used, there is another legal rule, such as a fundamental right to physical integrity, that can limit the discretion concerning the use of gloves in exceptional circumstances. And in the light of the fact that the exercise of discretion can affect legally protected interests, at least some legal systems have developed general principles for at least some areas of their law that serve to protect such interests. And if we stick to administrative law, German and European public law have developed general principles that restricts the exercise of discretion by public officials, and most prominently probably the principle of proportionality concerning infringed rights. Even if the police has discretion on how to enforce the legal order in the context of a public assembly, it will violate the principle of proportionality if they dissolve the whole assembly when the exclusion of some few participants that disturb the order would be as effective. And further, non-discrimination principles limit the exercise of discretion. Even if the exercise of discretion is proportionate, it remains prohibited to infringe upon rights in a discriminatory manner. And if I remember right from your exposition about discretion in English administrative law, there are at least also some non-discriminatory principles and principles that are probably close to proportionality ideas. So what stands out, though, is that in addition to these objective limits on discretion, in some legal systems, there are also subjective conditions that have to be met by officials exercising discretion. One subjective standard that is often employed to limit discretion is the condition that the discretion has to be exercised following the purpose of the law granting it. Not only must the measure taken be in accord with the purpose of the law objectively, but the official exercising the discretion must have been guided by the purpose of the law and not by different motives. At least in some legal systems, further subjective limits are generally applied to the deliberative process of administrative agencies. And thus it can be required that an agency must consider all relevant aspects of the decision, or that it does not make any gross errors in evaluating them. And these legal constraints on the exercise of discretion are either explicitly stated in legal rules, as some of them are in the German administrative codes, or developed in legal doctrine. They pertain to and describe certain general aspects of the application of the law that more specific rules do not refer to. And in this sense, they amend the description that the more specific legal rule provides by adding some other general features. Thus, a penal statute that orders a sentence of 5 to 10 years of imprisonment for a specific crime, in combination with the proportionality principle and anti-discrimination rules, could be read as a more complex rule. It would mount to the rule that the judge has discretion to determine a sentence between 5 and 10 years that is also proportionate and non-discriminatory. Discretion holds for those aspects that the law does not address, neither in its specific nor its general rules. Discretion is in the blanks. Thus, discretion can be defined as the non-legally determined choice from a set of legally defined options. Linguistic indeterminacy and descriptive incompleteness have to be distinguished in their nature, the methods used in law to resolve them, and their doctrinal treatment. And doctrinally, there is a startling difference between the general legal limits on legal constructions and the general legal limits on discretion. At least in some cases, legal interpretation and legal construction allow for either epistemic or substantive choice regarding the way the law is to be doctrinally developed. The general objective limits for these choices are often similar to the ones that limit the exercise of discretion, like legal constructions must not violate anti-discriminatory standards. However, there are usually no subjective general limits on the doctrinal development of the law to resolve linguistic indeterminacy. Legal systems generally do not question the motives that guided a judge to decide in favor of a particular legal construction and not another that would have been possible too. And this provokes the question of why there are no subjective legal limits on the doctrinal development of the law. I think next to procedural reasons that allow challenging the partiality of judges to occur more easily, at least as a factual matter, another reason lies in the stronger constraints on legal construction in comparison with legal discretion. Discretion allows for policy decisions that do not come with the temporal and systematic consistency requirements of legal constructions. They offer more leeway, and thus the exercise of discretion is more open to being influenced by inappropriate motives. Hence, the development of general subjective limits on the exercise of discretions, but not on legal construction. Despite this generally clear sense of the law of all these differences between linguistic indeterminacy and descriptive incompleteness, the clear sense does not prevail always. In some areas of the law, the two kinds of underdeterminacies are not always distinguished, and the two methods of resolving them are not always held apart. And the most striking example is probably administrative law. In some legal systems, several doctrines try to tilt the scales in favor of administrative agencies when it comes to the judicial review of their decisions. The basic idea behind this is quite simple. Courts are supposed to check whether administrative agencies have complied with the law. If, however, the law is linguistically indeterminate, there seems to be no legal standard the courts can apply to control the administrative agency. Thus, there's nothing left for them to do, but only for the administrative agencies in question to employ their pragmatic discretion. And in this role, they are better equipped than courts due to their greater expertise on the respective subjective matters. And this, for example, is the general idea that lies in the background of the Chevron doctrine in US American administrative law. According to this doctrine, courts are only allowed to control administrative agencies insofar as they can rely on an interpretation of the law based on a clear legislative intent. In as far as the law is indeterminate, the court is not allowed to impose, I quote from the US Constitutional Court in this decision, its own construction on the statute, end of quote. Instead, the administrative agencies ought to have, quote again, broad discretion in implementing their policies, end of quote, where the text of the statute is indeterminate. Similarly, the European Court of Justice only operates with one concept of discretion and applies it to justify deference to administrative bodies with respect to their interpretation of the law as well as to the discretion proper. And in parts of German administrative law scholarship, there are increasingly voices that German law should follow this approach of the European Court of Justice. They stress functional arguments in favor of limiting legal constructions by the courts along the lines of the Chevron doctrine. The German courts, however, are quite reluctant to follow. They only allow for a margin of appreciation concerning facts in cases in which it is too difficult to reconstruct them in the court or in which the administrative agencies are in a superior position to establish those facts. They insist, however, that the last word concerning the doctrinal development of the law has to be with the courts. And in the light of the above analysis, the reluctancy of the German courts seem well founded. The Chevron-type argument rests on confounding linguistic indeterminacy with descriptive incompleteness and the hermeneutic interpretation and construction of the law with the exercise of discretion. In as far as administrative law provides discretion, there is indeed nothing for the courts to decide. These issues are best left with the administrative bodies that have the pragmatic expertise in the field. As far, however, as the law is only linguistically indeterminate, its determination on interpretation rests on interpretation and legal constructions. And these might be affected by pragmatic considerations too, but they are first and foremost oriented toward the doctrinally consistent development of the law and not pragmatic considerations pure and simple. And this is a very different task than the pragmatic exercise of policy discretion. So while it's true that the pragmatic exercise of policy discretion is functionally better allocated to administrative agencies, the same does not hold for hermeneutic development of the law. The courts have a century-old experience in incrementally developing the law on a case-by-case basis with the longer-term interests of the legal system in mind. They are expert in the unique inferential connections that hold between legal concepts and norms in which the incremental amendment of the law has to be inserted. Through their judicial independence, they are institutionally best shielded against the fleeting political pressures of the moment. Thus, the functional arguments employed to support doctrines of the Chevron type hold only as so far as discretion proper is concerned. From a functional perspective, the doctrinal development of the law, however, seems better to be taken care of by the courts, with their special institutional protection against day-to-day political influences and their specific expertise in the doctrinal development of legal systems. This explains the resistance of German courts and also the growing pressure under which the Chevron doctrine has come. And I might as well stop here. Thank you.